When is notice considered adequate for due process? Imagine you're about to lose something important, your home, your job, or even your freedom. Before that happens, the government must tell you what's going on. That's where notice comes in. It's a key part of your rights under the Due Process Clause. But what makes that notice good enough to protect your rights? That's what we're here to find out. Notice is considered adequate when it is reasonably designed to inform you about what the government plans to do and gives you a real chance to respond. It's not just about sending a letter or email. It's about making sure you actually get the message and understand it. The notice must be sent in a way that makes it likely you will receive it. For example, if you're supposed to get a letter, the government can't just put it in the mail and hope it reaches you. It has to use methods that are appropriate for your situation, like certified mail or personal delivery if necessary. The notice must also include enough details so you understand what the government is planning. It should clearly state what action is being taken against you, why it's happening, and what you need to do to stop it. If you're told you might lose your license, the notice should specify the reasons and tell you the steps to contest the decision. It should be written in plain language, not confusing legal jargon, so you know exactly what's happening and what your options are. Timing is another important factor. The notice must arrive before the government takes action. If you get the notice after the fact, it's too late to respond properly. You need time to prepare your case or gather evidence. Usually, notice should come well in advance of the action, giving you enough time to act. In emergencies, the government can sometimes skip this step and act first, then notify you afterward. But these situations are rare and strictly limited. The Supreme Court has said that notice is a basic and fundamental part of due process. Without it, your opportunity to be heard becomes meaningless. You can't defend yourself if you don't know what's happening. That's why the notice must be clear, specific, and timely. If the government learns that its notice didn't reach you or was confusing, it must take steps to fix that. Sending notice once and claiming it was enough isn't acceptable if it never actually reached you. In most cases, notice must come before the government acts. This pre-deprivation notice lets you voice your objections beforehand. But in true emergencies, the government can act immediately and give notice afterward. Still, this exception is narrow and carefully controlled to protect your rights. When you're facing government action that could affect your rights, always check the notice you receive. Make sure it explains what's happening, why, and what you can do. If it's unclear or you never got it, you might have grounds to challenge the action. The government has the responsibility to ensure you get proper notice. If they fail, your rights are at risk. Remember, your right to be heard starts with proper notice, and that notice must be fair, clear, and timely to keep your rights protected.